Assalamualaikum and a very good morning. I be to our beloved lecturer, Madam Murshamsul Kamariah Binti Musa and my fellow friends. My name is Muhammad Farid Zakwan and together with me are Nurul Shafiqah and Arwan Najihah from Persona Group for Law and Equity. Foremost, we would like to introduce our group assignment presentation in which the question given is explain and discuss the maxim equity looks upon that as done which ought to be done. To what extent, if any, does this maxim operate to impose a trust on any person in a transaction? First thing first, we introduce our assignment by providing the concept whereby the maxims are primarily the working principles of equity, representing more than 500 years of equity courts judicial experience. These are considered to be established principles or propositions and a reference framework within the broader conception of conscience and fairness can be considered. Under common law, the judges develop legal maxims, which are usually expressed in fixed Latin form to justify the outcome of the findings and judgments of cases according to their conscience. By referring in the case of Aston Property Sendirian Berhad and Hampstead Corporation Sendirian Berhad, Gopal Sriram explained the applicability of equitable maxims in which it is beyond argument that equitable doctrines are not to be dealt with in a rigid fashion. They are by their very nature flexible and mean to be applied in such a fashion as produce a just result on the facts and circumstances of a given case. Furthermore, the maxim equity looks upon that as done which ought to be done means that when individuals are required to act of legal importance by their agreements or by law, equity considers that it was done as it should even prior to it done. This makes the legal phenomenon of equitable conversion possible. Moreover, the essential requirements to put the maxim in action are enlisted below. First, there should be a contract to transfer legal title. Second, there must be substantial evidence to prove the existence of that contract. Third, this contract should be capable to enforce. Fourth, the suit must be brought by the parties within the specific time. And lastly, the title so sought to obtain must have legal support.
Next, the application of the maxim can be seen operating in imposing trust in the case of contract of leases, the doctrine of conversion and conditional. The first one is contract of leases. A contract of sale and transfer of property is enforced once the seller executes the transfer. He is deemed to have converted himself to a mere trustee to that property until the purchaser takes physical possession. Basically, in the law of contracts, where a party has made a promise to fulfill an obligation, his obligation is deemed as fulfilled. We can refer in the recent case, which is in the case of Lohtina and others, again Kemuning Setia Sendirian Berhad and others, and another appeal, 2020. In these appeals heard together deal with the vital issue as to whether a development under the Housing Development Control and Licensing Act 1966, the HDA, and its attendant regulations can transfer a lease of a freehold subdivided title of a house on the ground that the purchasers have agreed to that. In this case, the judge highlighted to a principle quoted in the case of Johnson and another against Moreton 1978, in which if a party has made a commitment to perform an obligation towards an agreement or contract, the obligation is considered to be fulfilled and there is no way to simply neglect it or withdraw the contract that had been agreed. Also, we can refer in the landmark case, in case of Walsh against Lonsdale, 1882, the maxim of equity sees as done that which ought to be done has been enforced derived from this case. The application of the doctrine is when an agreement was created and it is specifically enforceable, allowing the equitable maxim, or more simply, creating an equitable equivalent of a formerly defective but otherwise legal lease. The doctrine will only operate where the contract underlying the defective lease complies with the Law of Property Miscellaneous Provisions Act 1989, in that it is in writing, contains all express terms, and it is signed by or on behalf of all parties, provides for consideration, and is specifically enforceable.
In the case of doctrine conversion, the doctrine convention is a principle that is closely related to the maxim what ought to be done as done, where the conversion is when a person is under a duty to convert a property of one to another, which may cause injustice as there is a failure to perform an obligation. The doctrine will assist the owner on the subject matter, like land or any other property subject to convert, to carry out his objective to distribute the party as referred to original intention, which in other words, the equity will assume that the sale had already taken place if a trust for the sale of land existed. Therefore, the beneficiary's interest was treated as it had already been converted into personality, although the land is yet being sold. The doctrine of later incorporated and replaced with Trust of Land and Appointment of Trustees Act 1996. So this can be seen in the case of Williams and Gilblanc Limited against Bolland, where in this case that Ms. Bolland was deemed to have an interest behind a trust for the sale, and the contest arose. The contest arose when her equitable interest and the interest of the bank as a mortgage of the legal estate. In this case, if the Miss Bolland had an interest in the land, and then she would have an overriding interest. But however, if her interest had already been converted into personality, then there is no such case in overriding interest, since the subsection only protects the rights in land. It was held in this case that the purpose of the doctrine was to simplify conveyancing in cases where the intention was to sell the land immediately. In this case as well, the doctrine should not be extended beyond that to a case where it was clearly fiction, and the Trust of Land and Appointment of Trustee Act provide that trust for the sale of land or replace trust of land with the power of sale, which means that interest behind the trust is also can be a part of an interest of land until the power is exercised. Another latest case in Fuji Sang and others of Fuji Tuang and another in 2012, but the parties in this case consist of the whole family where all siblings and the mother, and the testator is the fathers who create the will to sale of the property of the family home. The terms of the will provided that the trustees were directed to sell the property and have the power to postpone the sale in their absolute discretion and divide the proceeds among the beneficiaries. The rooms in the property were rented out for extra income and continued after her death. So it was held in this case that when the problem arises, when there is an agreement on how to property should be dealt with when all the siblings did not stay in the property anymore, and the appellants intended the property to be sold, but the first responded against all what have been disagreement by the appellants. So it was held that in this case, that in regards to the power given to the postponing the sale, which incorporated in the doctrine of conversion in trust of a sale, the judge carefully observed the application of doctrine in the trust is usually made in a matter of residuary gift, where a trustee has to exercise his discretion to deal with life interest and residuary legacies. Thus, it depends on whose interest that the trustee would like to protect in deciding whether to convert or not in such matters. Thus, in this case, the court rejected the first respondent argument. It also can be seen that exercise of an option in a lease agreement where the doctrine of conversion applied in the case of Laws and against Bennett, where a leaseholder is granted an option provided in the agreement to buy the freehold but is not yet being exercised as a freeholder, and the disposition of the rents pending the exercise of the option, and the purchase price shall be determined. Thus, the rents will go to the person entitled to the freehold applying this doctrine, which such rents would be residuary or a specific devisee, and must be noted that in order to pass the title to the residuary legatee as a conversion into personality, it is also subjected when the option is exercised to proceed with the sale.
Lastly, for the conditional contracts, this rule is based upon the presumption in equity that the testator who makes such a residuary bequest desires the property to form a sound and continuing investment for each beneficiary in turn, and although the rule may be excluded by proof that it conflicts with the testator's apparent intentions, the presumption of equity is that the rule applies. The rule derived from the case of Ho against Earl of Dartmouth 1802, which the principle stated that trustees must act impartially between successive beneficiaries and not favour the interests of one beneficiary, which is a life tenant, over another, which is the remainderman. The foundation of the rule is that if a residuary personality, the residue of an estate, when every other property has been distributed is given for the benefit of beneficiaries who are to enjoy it in succession, then the trustee is under obligation to convert such part of it as may be of a wasting or reversionary nature or consisting in an unauthorized investment into property of permanent and income bearing nature or into authorized investment.
In conclusion, several circumstances where the maxim will treat the act of the parties has already conducted their obligation as according to the contract, even if it doesn't take place yet. So the court practice in the application of the maxim can be seen mostly in the case related to the land contract matters, where it relates to the interest of the land, especially in the matter of trust. It can be concluded that the most of the trusts created based on the reported cases worldwide applied this particular maxim, as it affects the interest of the parties, which become the crux of the cases, and hence supporting the equity to assist in such matters. Thus, this maxim is applied to the extent of a trust matters, which can be seen in the lease contract, the applicable of doctrine conversion, and also the conditional contracts. That's all. Thank you.